What's the hardest element of a legal malpractice case to prove? Good afternoon. My name is Neil Burns. I'm an attorney. I've been practicing law here in Massachusetts for 40 years, and I've been asked to talk a little bit today about legal malpractice in the context of what's the hardest element in a case to prove. There's no clear answer. I mean, every case is different, but I can go through it a little bit to explain. So the first element in a legal malpractice case is, was there an attorney-client relationship? Well, that's not that hard to prove if there was one, but sometimes it's complicated. Does an attorney represent a corporation or an officer of the corporation? And there's laws on this, there's rules on this, there's cases on this, but that's usually not the case that we deal with here, the problem that we deal with. Then there's the duty. Did the attorney have a duty to do what we say he or she didn't do? So, for example, if you have a personal injury case, they have a duty to file suit on time, they have a duty to get the right medical records to the insurance companies, things like that. Duty is usually pretty clear. Malpractice case in bankruptcy, they have a duty to look at the documents before filing. Was there a proper homestead? We get this one a lot, where they didn't look at that document. So they have a duty, and that's usually relatively easy to look at, but sometimes it's complicated. In a divorce case, what did they have the duty to do? Was this a strategy, or was this a missed duty? And then was there a breach of the duty? Well, it goes along with duty. Did they not do what they're supposed to do? And you generally need an expert attorney as a witness for that. Then there's cause or proximate cause. Was the breach of duty the cause or the proximate cause of the damages? For example, in a car accident, the person has a broken leg before the accident. After the accident, their leg is still broken. It wasn't the cause of their damages. That's a very simplistic example, but lots of times it can be complicated, because the damages are not clear. And in a legal malpractice case, you have to prove the underlying case if there was an underlying case. So that goes through the same set of duty, breach of duty, causation, proximate cause, and all that. And then there's one that doesn't get brought up a lot and isn't in the law books, and that's collection. So you can win your case against an opposing attorney. You can win $1 million. You can win more. It's a piece of paper from the court, from a jury verdict or from the court, a summary judgment, whatever. It's a piece of paper that says you win, but you have to collect on that money. Otherwise, you didn't do this case for the piece of paper. It would be a Pyrrhic victory. So is there insurance? Does the insurance cover what you're saying was the legal malpractice? Or if there's no insurance, is there enough assets? Now, the TV lawyers sometimes have a high deductible, so they may not even involve an insurance company until it gets to a very high number, and that's fine. They've got a lot of money. They're self-insured, that is, up to a certain amount of money. And some lawyers who their action is not insurable. The sexual assault cases, for example, or they don't have insurance. So we have to look at that because that's a very difficult element to win. You're not really proving it; you're just winning on it. You have to collect, and we can have a collection case that goes on for years, and that's not fun for the client or the opposing attorney. So we look at all these different elements in the context of accepting or not accepting the legal malpractice case and how we address the problems and how we address proposing a settlement of one. So if you have a question, if you want a free initial consultation, call Burns & Jam, 617-227-7423. Thank you.